Did you know that Canadian courts have determined sexualized images of individuals under the age of 18, even when no private skin is exposed, have at times been considered illegal and categorized as child sexual abuse material? So, if someone possesses a sexualized underwear image of someone under the age of 18, can they get in trouble? And can they be forced to delete those pictures? Well, maybe. As digital literacy advocates working in schools and students, we often receive messages from students seeking help because their ex-partner or someone they trusted is threatening to post their nude image online. This is clearly illegal, and as you can imagine, the panic that ensues when someone reaches out for help in a situation like that, oh boy, red alert. But we've also received messages from young people claiming that their nude image were leaked on the internet, only to discover that what the image was in question was simply underwear pictures. Is there a difference between fully nude naked and semi-nude? While there may be some differences in what's actually in the image, it can certainly have the same emotional impact to have sensitive private images leaked publicly. According to court cases, even if clothing covers all the private areas, sexualized images of individuals under the age of 18 can still be deemed illegal given the context. Across Canada, there have been at least 8 court cases, both at lower and higher level courts, where images with clothing covering all the important private areas were still considered illegal. One court case even stated youth sexual organ or anal region did not have to be exposed in an image to constitute depiction of an image of child pornography. For instance, in 2011, BC Supreme Court case, an individual using a camera with a high-powered zoom lens was zooming into youth private parts in a public park where many people were wearing swimsuits. And the court ruled those images as illegal. If you're thinking, well, it's a public park and there's no expectation of privacy in public, well, the court determined that people do have an expectation of privacy in public to not have their private parts zoomed in on and recorded. Similarly, in 2010 in Ontario, a court case of an image depicting a young person sleeping, fully covered, but with an adult hovering their genitals above the young person's head while they were sleeping. The court ruled that the image was clearly depicting a sexual act and found it illegal, even as the young person was in no way naked. If you're wondering, yes, AI or edited images of young people are also included in this, as what happened to a man in Quebec arrested and sentenced to prison for exactly doing that. In our work, we often discuss the crime of taking someone else's fully nude image with all the private parts exposed and distributing, showing, or sending it or making it public. This falls under Criminal Code Section 162.1, publication of an intimate image without consent. This applies regardless of age. If these images involve someone under the age of 18, Criminal Code Section 163.1, child pornography, could then also apply. You might be wondering why any of this even matters, because if someone under the age of 18 sends a nude picture of themselves to another teen who they're dating, wouldn't that also be just illegal? Well, if you read the Canadian law as it's written, it would seem so. However, we must consider how courts interpret these laws. Just because something is written by the government in legislation doesn't necessarily mean it's applied exactly as written, especially when situations conflict with one's rights In 2001 and 2015, the Supreme Court made some narrow exceptions. In summary, in Canada, it's not illegal for two teens under the age of 18 to possess or exchange naked nude photos of one another. This also applies to teens who take private nude selfies. Cheese! They won't be arrested for it, at least not in Canada. Although, in other countries, many might have different rules. However, it is crucial that sending a nude image in a relationship is consensual, lawful, and not exploitative. Those are some of the conditions created in that exception by the Supreme Court. So, if two teens consent to send each other nude photos of each other, and they are similar ages, there's no power imbalances, no threats or violence involved, then it's not illegal in Canada. Preventing teens from expressing themselves in this way within relationships was seen by the Supreme Court as a potential violation for their freedom of expression. However, it is illegal to distribute such images beyond the privacy of the relationship. Sharing a nude picture that was received from a dating partner with a best friend, for example, would be a big no-no. This is also applying not just what you can send, but simply having a photo on your phone and just showing it to your best friend. No, 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 no. This ruling was quite controversial all the way back in 2001. And whether you agree with it or not, I'm just simply conveying what the highest courts have stated. In 2015, the Supreme Court of Canada suggested that young people under the age of 18 can withdraw their consent for the possession of nude images of them at any time. This is significant because if a teen sent a nude image to their dating partner under the approved conditions but later regretted it, or fears that it might get leaked or they're planning to break up with their partner, if they request deletion of their nude image to withdraw that consent for their partner or their ex being in possession of those nude images, if the other person refuses to comply, they could be breaking the law, as suggested by the Supreme Court of Canada. This situation would have to be brought to the court to test, but the Supreme Court heavily suggested to side on the person who is depicted in the image. However, it is important to note that Section 163.1 regarding child sexual abuse material does not require private skin to be showing as demonstrated in court cases across the country. For any teen in possession of a nude image or sexualized image of their partner also under the age of 18, here's a warning. Sharing your partner's semi-nude image may not be illegal in your specific circumstance, but could there be grounds for your partner and the police to launch an investigation? Possibly. Regardless of the content, if your partner sends you something privately, should you be showing it with others? If so, is that even a relationship for them worth maintaining with you? While distributing nude images without consent is illegal regardless of age, when those images involve folks under the age of 18, the legal consequences can be more serious. Additionally, 8 Canadian provinces have civil liability laws regarding distribution of intimate images without consent, with some also including nearly nude in their definition. So distributing such images could lead to legal fines and damages to be paid to the persons whose image was shared. Not only can there be criminal consequences, but also civil consequences like a lawsuit. Here at the White Hatter, operating in public safety for over 30 years, not everyone we work with wants to get the police involved, and understandably. There are steps that can be taken individually to address some challenges here. We have a resource document called the Youth Deletion Notice of Images, Videos, and Other Nude Media Request Letter. Big name, but we have seen this used with great success. It cites various court cases that I've already mentioned and serves to be as a written notice withdrawing consent from someone to be in possession of a nude or sexualized semi-nude image. Again, images shared in a relationship that are consensual, lawful, and not exploitative, not immediately illegal here in Canada. But now it's on a member in a relationship to withdraw any of that consent. This is where that notice takes effect. You could imagine saying to your ex to delete an image might not make them do so. This is a document that we outline court cases backed by our own trademark, and this can make your request more effective. Plus, trying to prove to police that you told your ex to delete images can and possibly be a bit difficult. This document can help function as a paper trail to use in cases where your images that were sent were not properly deleted. This can be used to show the date and time of when you made that request. If you are a teen or someone younger and a nude or semi-nude image of you is being shared, please reach out to help make that stop. There are police members, your family, school staff, and students even message us here in the White Hatter with questions all the time on how to best deal with online challenges. There is a network of people who want to help you succeed and have the best online experiences. We are intensifying our commitment to combat sexualized abuse material, regardless of its form. Our efforts extend beyond solely addressing fully nude images. We have provided assistance to individuals whose intimate images, whether they are fully nude or semi-nude, have been leaked or threatened to be exposed. The emotional distress experience is equally distressing, and this is unacceptable. We aim to make a difference by using new legislation and court interpretations of existing laws. Our mission is to aid teens who have to grapple with the challenges of online spaces where sensitive, private content is maliciously used against them, and this is not acceptable. And it serves as one of our motivating factors driving our work. If you are motivated to learn more about this, check out our website, thewhitehatter.ca, but also stay subscribed to our channel as we build more resources to share with you. Have a great time online and stay safe.